Randolph Vines, Mr. Rojas. Mr. Rojas is getting a gold star this morning.
It's been a while since I had one.
Rusty star.
Luke deserves to have to put out. Most of these cases are yours.
True.
Oh, well, y'all might have to share a star, huh?
Sure.
I don't require.
I'll take the
I don't
whole
mind.
thing.
It's always nice to get a gold star.
Do I still have it? No.
Good morning. Are you Randolph Vines?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Vines, in cause number 25 DCCR 1154, the state has elected to proceed on count 1 only, and in that count to the lesser included offense of a Class A misdemeanor, unlawful carrying a weapon, from June 29th of 2025. And how do you plead to that charge?
Guilty.
And are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand that?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And are you a U.S. citizen?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Vines is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, and at this time find you guilty of the lesser offense of unlawful carrying a weapon, sentence you in accordance with your agreement to a term of 90 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive.
Yes, ma'am.
I feel like you obviously know this based on what you're charged with, but I'm required to read it. And now I forgot where I was, but illegal charges against you. If you have any questions about what, you should read the document I provided you. I don't know. I lost it totally. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long it lasts, you can talk with Mr. Rojas.
Yes, ma'am.
You can go back with the bailiff.
Your Honor.
That's what I get for not reading it. I'm reading it in my head. I don't even know where my copy of it is anymore. I've read it, I've said it so many times. But I can't stop in the middle and then restart. That's not good. Lamone Yeoman, Mr. Rojas. Give me just a second. I'm going to print these out. They're both MTRPs, and it's just easier to find me. 19. Good morning. Are you Lamone Yeoman Jr.?
Yes, ma'am.
And will your client waive the formal reading of the motion in each case?
He will, Your Honor.
Let me get on. You should have another one coming also.
Excuse me, ma'am.
Okay. Mr. Yeoman, in cause number 19-32846, I have a first amended motion to revoke your unadjudicated probation. This shows that you were placed on probation November 12th of 2019 for the offense of aggravated assault with a deadly weapon, and that was a 10-year deferred probation. Is that correct? And then in cause number 23, DCCR 1556, I have a first amended motion to revoke your community supervision. Shows that you were placed on probation July 17th of 2024 for the state jail felony offense of burglary of a building, and that was a 2-year term in state jail prison that was probated for 5 years. Is that correct?
Yes, ma'am.
Each of these cases allege that you violated your probation. Count 1 in each case alleges that you failed to avoid persons or places of disreputable or harmful character, and specifically avoid association with any person previously convicted of a crime, or be present at a location where a criminal act is committed, in that you were supplying other residents of the Cheyenne Center with K2 synthetic marijuana. And is that true or not true?
Right from the start, this case hits hard. Endangering a child isn't just legal jargon. It's one of those charges that instantly shifts the room's energy. Everyone knows what's at stake here: a kid's safety.
It's true.
Okay. Count 2 in each case alleges that you failed to report to the probation office as directed April 2nd and April 3rd of 2025. And is that true or not true?
True.
Count 3 in both cases allege that you possessed a drug, K2, on or about March 30th of 2025 in violation of your order. Is that true or not true?
Not true.
Not true? Okay. Count 4 alleges that you failed to successfully complete the safety program as directed. Is that true or not true?
True.
Count 5 in each case alleges that you committed the new offense of possession of a controlled substance, penalty group 1, August 8th of 2025. And is that true or not true?
True.
Count 6 in each case alleges that you committed the offense of possession of a firearm by a felon, August 8th of 2025. And is that true or not true?
Not true.
Count 7 in each case alleges that you failed to report to the probation department April 11th, April 21st, April 30th, and May 9th, June 6th, and July 7th of 2025. And is that true or not true?
Not true.
All right. Did you enter your pleas of true to counts 1, 2, 4, and 5 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
I think y'all did the paperwork backwards.
We did originally, then we corrected it. At least I thought we did.
So,
It is a cap of 8 on 19-32846, and a cap of 2-year state jail on 23 DCCR 1556.
well, it's set. Hold on. Anna, can you send me back 23-1556? I just sent it.
That may be the third degree paperwork. I think he may be right.
Yeah. Okay. I think, so 23-1556 is the burglary of a building,
Should be stated.
but y'all did TDC paperwork. And the other one, yeah. So it's got, those have to be right. So
We can read them.
I'm going to delete both of those.
That's fine, Judge.
I'll just hold this. We'll continue the hearing. I'm not going to go back over everything. We'll just go over the paperwork as soon as it comes through. And did y'all do it twice? You
We
said?
did, there was,
I got the numbers wrong. We did.
Okay,
I'll have to redo them both.
sorry.
That's my fault.
All right, I'm going to delete both of those. All right, y'all just go have a seat in the jury box and we'll get that done. Delete that. I'll keep these. I was looking and I was like, wait a minute, that's because I thought it was a Kappa 2 on the TDC case. I'm like, what? Okay.
Yeah, I forgot they were different levels. Luke talked a mistake. I thought they were different levels.
Okay.
Do you want to plead hindrance now, or do you want to do them when we do the other guy?
Go ahead and get that one done, and that way I don't keep this over here and get confused for too long, and I'll take care of a couple other things. Let's see. Mr. Kimler, you have Sheena Harmon.
Yes, sir. Judge, if I can, there's no family members here on the side too.
Yeah, which one?
It's Christopher James.
Okay, I'll take care of it next.
Thank you.
Would y'all put that Christopher James sentencing up here for me to do next, please? Thank you. Ms. Malfino on Colton Armstrong with Mr. Kimler. Is it yours?
This is Harmon. This is
What did
Harmon.
I-
You call
This is Harmon.
Oh, that's why never mind. Just testing everyone. Okay. Gosh, I feel like Monday. All right, are you Sheena Harmon?
Yes, ma'am.
Not Colton Armstrong? Are you sure?
Yes, ma'am.
Okay. And will your client waive the formal reading of the indictment?
So wait.
Okay, we're going on all of the counts.
Whatever
Or
makes
at
it
least,
third.
okay, got
Whatever
it.
gets us to what they're judges.
Okay, I got it.
I think we're going to need all of them to get us to it.
Okay. Ms. Harmon, in clause number 25, DCCR 0649, you're charged with the state jail felony offense of tampering with electronic monitoring device, and that's from April 30th of 2025. The indictment alleges that you were previously convicted of the state jail felony offense of theft, June 28th of 2010.
12 months sounds light until you realize this is a state jail felony that means no parole, no early release. He's serving every single day. This isn't just punishment, it's a statement.
And then you were also convicted of the state jail felony offense of theft on June 24th of 2013. And on that same date, the state jail felony offense of possession of a controlled substance. And how do you plead to that charge? And are those prior convictions true?
Yes, ma'am.
Did you enter your plea of guilty freely and voluntarily?
Yes, ma'am.
And because you actually did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kimler?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Harmon is not competent?
There's none.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily, find those prior convictions true, find sufficient evidence to find you guilty, and at this time find you guilty of tampering with electronic monitoring device, sentence you in accordance with your agreement to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. I will also hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Kimler.
Yes,
All right, good luck to you, ma'am. You can go back with the bailiff.
We're pleading this as a third degree.
Thank you.
He's gonna have to plead true to everything else. I guess there's some version.
No, I'm
I don't mean,
take it back.
just here.
Good morning. Are you Colton Armstrong?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
So wait. One, two.
Mr. Armstrong, in cause number 25, DCCR 0002, you're charged with the state jail felony offense of theft of property from February 21st of 2024. Your indictment alleges that you were previously convicted of the state jail felony offense of driving while intoxicated with a child passenger, October 31st of 2022, 2 cases on that same date of that same offense, making this a third-degree felony punishment range. And how do you plead to that charge?
Guilty.
And are those 2 prior convictions true?
Yes, ma'am.
Did you enter your plea of guilty freely and voluntarily?
Yes, ma'am.
And did you plead guilty because you actually did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Kimler?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 10-year term in prison, but that would be probated. You'd be on probation for 10 years. There would not be a fine, but you would be ordered to pay restitution in the amount of $20,000. Is that your understanding?
Yes, ma'am.
Do you also understand, excuse me, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State Tenors Number 1.
Without objection. There's
It's admitted. Is there any evidence that Mr. Armstrong is not competent?
none, Your Honor.
Short but strong 90 days might sound easy, but losing 3 months of freedom for one bad decision sends a clear message Texas doesn't play when it comes to unlawful weapons. What do you think, fair or too harsh?
All right, sir, I'm going to find that you entered your plea of guilty and true freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to restate your case so that the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we'll come back at a later date for sentencing. Ms. Malfino, what's the state's position with regard to bond?
Judge, may I just put one thing on the record first before that?
We're gonna come back for some.
Obviously, I was a little bit hesitant to make this offer based on those priors, and I just want Mr. Armstrong to be aware, I have relayed this through his attorney, that if he does not pay this restitution back, I won't be asking for the minimum that I offered him today, 15 months. I'm going to ask for 10 years based on the opportunity that he's been given. I don't know that he doesn't have a hold in Hardin County. And I'm not saying that disrespectfully. I just want him to be aware of what he's just gotten himself into if
Sure.
the court follows the PSI. So I don't know if he has any holds.
I believe he does.
I'm a little hesitant to allow him on bond before you review the PSI, but I'll defer to what you think.
It sounds like based on that, and there is a hold from another
I
county.
can't say that they put a hold on him. I don't know. I know he has pending cases in Hardin County. I can't speak to whether there's a detainer on him from Hardin
And I've
County.
tried to reach out to Mr. Hopper over there and not get much.
Join the club.
Bruce.
And just like that probation gone 3 years behind bars, this is the side of the courtroom few people see when second chances finally run out.
Yes,
I
ma'am.
think he has an unauthorized use of another vehicle and a theft of the same vehicle in Hardin County.
He does have 2 Hardin County holds.
So those would have to be cleared as well.
Yeah, and by the time, I'm afraid if I set a bond and then they get them over here, then we're not going to get the PSI. It's just going to prolong everything. And I think I'd rather go ahead. I'm not going to adjust the bond at this time. Let's get it taken care of. And then as soon as sentencing gets here, if everything goes well, you'll be released, at least from our custody. And then you can go take care of your Hardin County cases. All right, you can go back with the bailiff.
Thank you.
Thank you.
Thank you.
That line says it all. A pattern in the justice system. That word carries weight. It's not about one bad day anymore. It's about proving you can't or won't change. And when the judge hears that, mercy fades fast. Tampering with an ankle monitor, that's like cutting off your own lifeline. The court sees it as spitting on the very deal that kept you out of prison. When the judge says 6 years, the silence isn't surprise, it's reality.